All right, Crim 28, let us knock out Chapter 7, Community Supervision, Modification, and Revocation. Okay, here are your learning objectives. You can read this, and you can pause it if you really have a strong desire to read all of these. But we're going to talk about termination, basically making changes to someone's grant of probation and or parole. Termination of probation at any time during a period or after some time has been served. So if someone is doing really well on probation or parole, it is possible that that person's grant of probation or parole can be terminated early. Typically, this is going to be a court or parole board function. So someone has to actually grant this. It's not something that's just naturally happens typically. And I'll be very honest, as a probation officer for 20-ish years, very rarely did I request someone's grant of probation be terminated early. There were a couple circumstances where maybe I had a young person who was planning on going to the military, and they had done ultimately perfect on probation, and they were not going to be allowed to enlist unless their probation terminated. So I might have made an exception and requested that a judge terminate their probation early for that reason. But I can't say, honestly, that it happened that frequently, but it is possible. Unfortunately, it was more often that we did the revocation or asked that their probation be revoked. And that means that it be kind of taken back, meaning that they be detained or locked up because they're not taking care of business because they are non-compliant with their probation and or parole. So there are two types of violations for probation and or parole. You have a new law violation. I know it doesn't say new here, but we call them new law violations or law violations, or a technical violation. A new law violation is just that. The offender, while on probation or parole, breaks a new law. So while they're on probation or parole, they go out and they commit another misdemeanor or felony. So I'm on probation and I go out and I steal another car. New law violation. So it's a law violation, but it's a violation of their probation or parole as well, because while they're on probation and or parole, they are ordered to obey all laws. Okay, so that makes sense. That's a new law violation. As opposed to a technical violation. One of the terms and conditions of probation is typically, or parole, report any change of address to your probation or parole officer within 48 hours. So your probationer or parolee moves, and 6 months later he has not told his probation or parole officer, and they have no idea where he is. That is a technical violation. It's not a real law violation, but it is a violation of their terms and conditions of probation or parole, so it's a technical violation. So those are two different types of violations. Absconding from community supervision. This one is very, very, very common. Some of them just literally move and they think that magically the probation officer or parole agent is supposed to know where they went. Or they'll say, I couldn't find your phone number. That one was probably one of the most common ones. I'm thinking if I'm going to lose my freedom, I'm going to remember how to make contact with my parole or probation officer. But this is not how probationers or parolees think. But this is a really frequent technical violation of probation that oftentimes people ended up in custody for that. Sometimes it could be listed as a new offense because it was escaping would be considered a new law violation. I know it sounds kind of contradictory, but if you are on probation or parole and you escape from supervision, there is a penal code section that is called escape, which is typically a felony. That can be filed against that offender as well. But this is probably one of the most common ones. You are going out to check on your probationer or parolee and they no longer live at the last address they gave you, you request a warrant for their arrest. They end up getting arrested 3, 4, 5 months later. You know, they have no idea why they're being arrested, even though they haven't had contact with you for 3, 4, 5 months. And they, oh, I moved. Well, you didn't tell me. Anyways, most states do take a passive approach to locating these types of fugitives because there are so many. If you go to the probation office, we had we had an entire room that was full of case files for warrants for people who had absconded from probation supervision. So every now and then we would say, okay, you guys, it's summertime. The students aren't, and I worked with juveniles, so the kids aren't in school. So let's go do a warrant sweep. And we would go and, you know, everybody would pick out, you know, 5 case files and we would go and look for them. But typically it's very passive. We're usually going to come across the people eventually. In-house progressive sanction options. Okay, so this is a fancy way of saying sometimes we have offenders who would commit some technical violations, like test positive for marijuana, like maybe fail to attend their drug treatment program, like maybe they, you know, let's say for a juvenile, they didn't attend school regularly. Well, their violations were not so serious that we were ready to revoke their probation or parole, but they still needed to have some sort of consequence. So what we would do is what we would call an in-house consequence. Sometimes that would mean, you know, do community service. I'm gonna give you 10 hours of community service to work off that violation. Or we're gonna have you write an essay about why it's important to go to school. Or I'm going to have you show proof that you applied for, you know, 5 different jobs. It never fails. I'm telling you, that phone always rings as soon as I hit record. Or we're going to have you show proof of applying for 5 different jobs, or whatever it is. So what we do is try and deal with the technical violations informally, so that the offender doesn't end up back in jail or prison. So sometimes, you know, we talk to our supervisors and run it by them and say, what kind of in-house lower level sanctions can we offer this defendant before we take him back to jail or prison? But let's say we've gone through all those things and the offender is still continuing to commit these technical violations. Then we start the revocation process, and this is to revoke their grant of probation or parole. That happens after we have exhausted those things. And there's a lot of work involved in revoking probation or parole. A lot of paperwork, first and foremost, and there are a lot of very specific rules, state, local, agency rules, and constitutional rules that guide how you do that. And it does begin with a violation report, warrants, citations. There's a lot of paperwork involved. Notification, the client has to be notified by law that they are being, that you are asking, you as the probation or parole officer are asking that their grant of probation or parole be revoked. They have a lot of statutory rights, and we're going to go through that. It is a 2-stage process. Initially, they go to the court, and the judge and the defendant have the right to inquire as to whether or not there's enough evidence to prove that there was an actual violation. And I would be, you know, honestly, as a probation officer, if I didn't have a slam dunk, as we call it, case, I wasn't going to take the client back to court. And by a slam dunk, I would say I had a lot of evidence on the offender's violations before I took them back to court. I wouldn't just take them back for a dirty drug test. I would take them back to court because I had, with a lot of information because I didn't want to have to deal with basically putting on a trial to prove that the defendant was guilty of a probation violation. And I never had, again, almost 20 years there, I never had a case go to trial where a probationer said, no, I didn't violate my probation. She's lying. Good, bad, or otherwise, I never had that happen. But I also was never going to take a case back if I didn't have, like I said, a slam dunk. So you'll see here the due process. We're going to talk about that a little bit further. But a hearing they have a right to have a hearing before a judge before probation or parole can be revoked. It wasn't always like that. And you'll see here, the legal issues, probationers and parolees have gained a lot more rights in the court system over the years. It wasn't always like that. Probation officers and parole agents could just throw them back in whenever they wanted early on in the United States. But now they have to have written notice of whatever the violation is, disclosure of evidence. So if I had dirty drug tests on them, I had to give them copies of those dirty drug tests. If I had proof that they had moved without telling me, I would have to bring proof that, so-and-so now lives in this house. They had an opportunity to explain their side of the story. They had the opportunity to cross-examine witnesses, which was typically going to be me. I was the probation officer accusing them of violating their terms and conditions. They had the right to judgment. They had the right to have a judge say whether or not they violated the terms. They are not going to have a jury. And I also had to provide a written statement for the reasons. Again, they were not entitled to a jury nor a speedy trial, not entitled to Fifth Amendment privilege against self-incrimination. And this is interesting because I read this and I said, this is not true, but apparently it is. 1973, this court case decided that they are not entitled to a court-appointed attorney. And I'll be honest, I've never seen a case, a probation revocation case, go in the courts without an attorney. And as I read more about this case, basically it says some states routinely provide counsel in probation revocation hearings. So California does that. It's not fair for a client to not have an attorney in these hearings. California does give probationers and parolees attorneys in these hearings. So interesting, their rights are limited, so they don't have all the exact same rights, but it's a different type of hearing, and it's also a preponderance of the evidence. That's the burden of proof in this case, as opposed to beyond a reasonable doubt. So there's some differences between a parole revocation or probation revocation hearing. Anyways, I think I jumped the gun there. Blah, corroborated, does the information fit, blah, 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 blah. Level of proof, we already talked about that. These are some other kind of sort of random things, but I had a case where a young man, he was under 18 at the time he committed this offense, but he went out to a farm area and he shot and killed something like 10 horses out on some little old man's farm. And he shot each one of them in the head with a .22 caliber gun. And for those of you who are familiar with guns, that's a pretty small caliber. So you can imagine all those horses, he shot them each one time. So they probably suffered. And all the horses died. Horses are not cheap. Again, for those, I don't know that much about horses, but I know that they're not cheap. So I had this young man on my caseload. He then turned 18, 19, 20, 21. I had him forever. And he owed the little old man whose horses he killed $100,000 and never paid a dime. And I was super frustrated, and I tried to revoke his probation based on the fact that he hadn't paid any of the victim restitution. And it was really frustrating because I could not violate his probation based on the fact that he did not pay victim restitution. I couldn't prove that he could afford to pay it. So that's a really tough one. And the next little bullet here, that time on probation or parole, certainly in California, is not credited. So let's say you're sentenced to 5 years in prison, and you do 4 years on probation, and then you violate your probation and you get sent to prison. You don't get credit for those 4 years that you were on probation. You could do the whole 5 years in prison. You get credit for 0 days because that time you were on probation, you were not locked up. Does that make sense? Anyways, all right. Recidivism and offender characteristics. Okay, so there's a page in your book that talks about recidivism rates, and recidivism is when a person completes a correctional program, whether that's probation, a commitment to prison, jail, whatever, parole, whatever, and then they reoffend. How long they're out before, and there's a chart on page 173 in your book, and it talks about gender, race, ethnicity, age, education, and how that all impacts their likelihood to successfully complete probation supervision and their recidivism rates. Time of revocation, I think they said that the majority of people, if they were going to have their probation or parole revoked, that it was going to be within the first 3 months. Recidivism rates of released prisoners over time. There is, so the information about that is on page 174. Why have revocation rates increased? That's also on 175. They talked about things like probation caseloads being so large that probation officers did not have time to actually meet with their offenders and talk about why they were reoffending. They didn't have the time to actually meet with the offenders and offer them services. They didn't have, they said that probationers were being given too many terms and conditions to comply with. They said that there were a lot of advances in technology that helped probation officers to detect drug use. So there were a bunch of reasons listed in your book on page 175 that talks about why revocation rates have increased. And then alternatives to incarceration for technical violations. What I can tell you in California now, what we are doing is, first and foremost, most parolees who are violating parole are not going back to prison. They may do some time in jail. We also have the halfway house type of program where they call it a halfway house because it's halfway, you're considered halfway in custody and halfway out. But these are houses that are out in our communities where people are supervised and live under certain rules, but they're still out in the community. We also have things like that are called day reporting centers, where offenders are going during the day and they receive their services. They are applying for jobs. They are doing substance abuse treatment, that kind of stuff. They're going there from 8 to 5. You've got to be kidding me. That phone never stops ringing. 8 to 5, Monday through Friday. And then they go home at night because it's cheaper, honestly. So that's the end. We made it. Yay.